Mr. Rosenkrantz, you have John Glazier. And like I said before, we have the D. Warner trial stuff going on next door. So your attorney will probably go to Judge Olsaver first. So I'm going to pop you in the waiting room until he gets here. All right, I have a gentleman with a hat on. Do you mind taking your hat off on a Samsung device? Yep. What is your name, please?
Sorry about that, Your Honor. My name is Ryan Matthew Bates.
All right. It's okay. I know it's cold out. Who is your attorney?
It's oh my goodness, Underwood. Miss Underwood.
Underwood. All right. So I'm gonna put her initials after your name, and then I will pop you in the waiting room. And when I get her, I'll bring you back in. All right.
Okay. Thank you, Your Honor.
Thank you. All right. So who has a case in here today? You do, sir. What's your name?
Dan Foster.
Dan Foster. All right. So I am going to mark that you're in person, and you have Mr. Malaro. And what is your name? Okay, Mr. Agulli. You also have Mr. Malaro. And you have a case, sir. What's your name?
Dan Canablo.
All right. Not a problem, Mr. Canabla. All right. So all of you are able to appear via Zoom because I see you're probably on your way to work. I'm going to give, who wants Zoom instructions for the next court date so they can do it on their phone? Okay. So if you have a smartphone, you can download Zoom and we'll give you connect or a laptop and you could Zoom in instead of having to drive in.
I didn't know that.
Well, now you do. So, huh? I don't know, but you're always allowed to Zoom in unless I tell you you can't.
Okay, I never knew that.
Yeah, so. Okay, and Mr. Canabla is Mr. Glazier. All right, so I'm heavy on clients, but I do not have any PDs yet. All right. So like if you want to download the Zoom app now and scoot to work, you can do that.
My phone won't allow me.
Oh.
It has no memory space.
Huh?
It has no memory space. It's an old phone.
Oh, okay.
I was just trying to do it actually.
Okay. All right. Mr. Igulli?
Yes, ma'am.
Oh, she was asking what your name was, I think.
Yes, Judge. Thank you, Judge.
All right. Okay. Hi, Mr. Vanetto. You on my bench trial today?
I am. I'll be talking back and forth.
You're early.
Very early.
It's like 2 hours. go to Judge Savers and check, because literally everybody went to his court. Someone could come to mind.
I can't be there at the same time.
1, 2. There he is. The only person I see is Brenda and Jen. Okay. There's a lady on YouTube that watches our channel, but she must have 2 devices because she's on his 2 at the same time.
Seems in the hallway.
See, who is it?
Dave faced up with a couple of his clients. But now see if he can sit in this courtroom.
It's okay. All right. No problem. Judge will get his docket. What's that? Bench for a minute.
Wonder if our lawyer's tied up in that shit store. What? Wonder if our lawyer's tied up in that stuff next door. No,
Probably.
that's something, they're like for case. Sure.
Yeah, go ahead, sir. You need a cup for water or anything? Right down the hall there. That correct, ma'am? Notify you, okay? Are you? Oh. Because it-
Good morning, Mr. Murphy.
Please rise for court's now in session. May be seated.
You're our favorite PD now because you came down. Watching all of them sitting down there waiting for Judge Olsaker. Except I probably don't have anybody for you, but hold on.
Well, I haven't sort of,
Okay,
the only person.
that's kind of anticlimactic, actually. Because I've got so many people. All right, Mr. Rosales, you want to start your video, please? Right there, Mr. Rosales, because I could see the ceiling. All right, Mr. Rosales, you want to unmute your device? All right, I can hear you, Mr. Rosales. I gotta see ya, okay?
Where'd that guy at run his mouth? So judge can hear it, dude. Hold on. Hey, where'd that guy at run his mouth so the judge can hear it, dude?
He knows they brought him into the court.
Talking about what?
He just unmuted his phone. Mr. Rosales, can I see your face? Isaac Rosales? He's got his hand up now too. Were you getting a date or any plea?
Well, I actually just texted Mr. Bayanetto. He had some issue to address in regards to the trial. So I'm not sure. It's just my understanding. We have a trial scheduled on this for.
February 17th?
Yep.
Isaac Rosales, can you engage? Come in front of the screen, talk to me. has an issue with the trial, you or Mr. Bayonetto?
Mr. Bader said that one of the witnesses, one of the officers is not available at the time.
All right, do you want to text him, and see if he can?
He said he's coming. So.
Okay.
Right here.
He said he's here.
Isaac Rosales, can you
Yes,
hear
I'm here.
me?
Yes, I can
Okay,
hear you.
good. Can I see your face?
Yeah, right there. Can you see my face?
No. Are you on a laptop or your phone?
I'm on my phone.
Okay, I can't see you, but okay. So this is in the matter of the people of the state of Michigan versus Isaac Rosales, file number 25-22346FH. This is the date and time scheduled for a final pretrial conference in this matter. I have Matthew Murphy appearing on behalf of Mr. Rosales, and I have Alexander Bayonetto appearing on behalf of the people. Motion deadlines were scheduled for today. Jury instructions were required along with voir dire questions to be provided by January 30th. Was that completed?
It was, Your Honor, not by January 30th. That was my fault. Mr. Murphy had sent over a stipulation to the packet that didn't get filed with the court, but it should be as of yesterday.
Okay, so Mr. Murphy has advised that you have some concerns about trial.
Yes, Your Honor, I do have one of my necessary witnesses, Officer Ross, who is, I believe, the subject of count either 5 or 6. Informed me yesterday he was unavailable. I did ask Mr. Murphy if the defense would object to an adjournment. I'm not sure where they.
So this was scheduled 3 months ago.
It was, Your Honor.
So why is he unavailable?
He says it's for a training, Your Honor. I did tell him that the trial was scheduled and it's been pending for a long time.
So
that I would make the request and.
he's gonna have to make himself available.
That's fine with me, Judge.
Okay. Mr. Murphy?
Your Honor, ultimately, I couldn't see it impeding the cases, but I expressed with Mr. Bayonetto the concern of the case pending for so long, and Mr. Rosales. I know Mr. Rosales didn't want to, so we had, I guess, something else to address.
Okay, so the trial, that witness will make himself available. Okay, what's the other issue?
That was the only issue.
Okay, so it's been pending for 90 days, so, you know, he gonna have to make arrangements. In this case, Mr. Rosales is charged with 1 count of felonious assault, which is a 4-year felony, count 2 felonious assault, which is a 4-year felony, count 3 felonious assault, which is a 4-year felony, count 4 felonious assault, which is a 4-year felony, and then 1, 2, 3 counts of police officer resisting and obstructing, which carry a maximum penalty of up to 2 years in prison. Felony firearm with a pneumatic gun is a 2-year felony, which requires a mandatory 2-year felony or 2-year term in prison. So that's count 8 and count 9 and count 3. So those, well, and count 4 or 4 counts of felony firearm, which are mandatory 2-year prison terms. He has no prior felonies.
No, Your Honor.
All right,
No,
and the plea offer is,
I'm a perfect
The-
student. Went to Madison.
You're
kindergarten
what?
12. I'm a perfect student. I went to Madison kindergarten to 12th and I passed all my classes at the.
so
National
Mr.
University.
Rosales, that is irrelevant to the fact that you have felony charges. So I'm just going through what your charges are. So the plea offer was to plead to 2 R&Os, which would be like a probation term. Is he eligible for HIDA?
No.
He's not eligible for hiding.
Not eligible for HIDA. So the plea offer is 2 counts of R&O, which are 2-year felonies, but they are eligible for expungement.
Yes, Your Honor, and there's also a Killebrew agreement to no jail.
Okay, so the plea offer is 2 counts of R&O. He would be eligible for expungement after 5 years after release from probation. There would be no prison term and probably 18 months probation. If he's convicted at trial, he will be remanded to custody and he's facing a 2-year prison term for sure on the felony firearms if he were convicted on that because it's mandatory. All right, so that plea offer is still available.
It is, Your Honor. Yes.
Okay, to the day before the trial, once the jury is called, that plea is not available. So, Mr. Rosales, your trial is scheduled for February 17 at 9 AM. Do you understand that?
Yes, I understand.
All right, and Mr. Murphy, does he need to reach out and meet with you?
Yes, Your Honor.
Yes,
Mr.
yes.
Rosales, could you call my office, schedule appointment soon?
Do you have time available?
Just please, you know.
I don't want you to say anything about your case. I'm just.
Mr. Rosales, so
Yes,
listen,
yes.
we're in a court proceeding.
Yeah.
Mr. Murphy is your attorney. He doesn't want you to say anything about the case. Whether you were a good student or not, or exemplary,
student.
that's great, but it doesn't matter if you get convicted at trial because it's a mandatory prison term. You need to schedule a time. I'm gonna give you a date and time to go meet with Mr. Murphy here in just one moment. You're gonna write that down and you are going to show up at Mr. Murphy's office and meet with them. Mr. Murphy, when do you need to see him?
Monday at 2 o'clock in the afternoon.
So, Mr.
But-
Rosales,
Yes.
Monday at 2 o'clock, you need to be at Mr. Murphy's office and meet with him. You understand that?
Yeah, that's fine. I just want to remind you that this is just a broken BB gun.
What?
You're
The
talking about the
broken-
item involved, and I don't want the court. Again, I don't want you talking anymore about it.
Okay. Well, I'll be there Monday, 2 o'clock.
Mr. Rosales, stop. We're going to trial on February 17th.
Okay,
I
February
just went through what your charges were, what would happen if you got convicted, versus what would happen if you took the plea. I'm not saying you'll get convicted because I'm not the jury. I'm just giving you, making sure you understand. You will be at Mr. Murphy's, stop, don't talk over me. Mr. Murphy will be waiting for you Monday at 2 PM, so make sure you show up at his office, all right? Say yes.
Yeah.
All right, thank you. We'll see you back on
Thank you.
February 17th. I expect everybody here by 8:30 at least to make sure we're ready to go.
Yes, thank you, Mr. Rosales. I'll talk to you soon on Monday.
All right, thank you, Mr. Rosales. Mr. Murphy,
Yeah,
we'll
thank
see
you
you
so much.
Monday. You're welcome. All right, Mr. Glazier. Let's see here. I have, Mr. Glazier, Mr. Knobloch. So, Mr. Knobloch, if you want to come stand at this podium, please. Yep, just stand right at that podium, adjust the microphone as you need to. All right, this is in the matter of the people of the state of Michigan versus Daniel Mark Knobloch, file number 25-22389FH. I have John Glazier appearing on behalf of Mr. Knobloch. I have Isaac Sneed appearing on behalf of the people. This is date and time set for a pretrial conference in this matter. Mr. Glazier, how would you like to proceed?
Your Honor, I believe my client, I think they've offered him a DV deferred. And I think he wants to avail himself of that. I just wanted to make sure that would not involve initial upfront jail, and deferreds it usually doesn't.
Okay, so Mr. Sneed, I do see that count 2 is domestic violence. I do see that the prior plea offer was plead to domestic violence first offense under 769.4A, which I believe is the misdemeanor deferred statute. So is that a correct recitation of plea, and what is your position on upfront jail?
That is a correct recitation of the plea, and we don't have any position on upfront jail.
So, all right, so Mr. Glazier, if they have no position, then I would have no objection, no upfront jail as a cops.
Okay, then we're set to go.
All right. Do you want to do this? All right, so Mr. Knobloch, my bailiff's gonna hand down to you an advice of rights form. I'm gonna go through those rights with you, but if you could read through it real quick. Go ahead and read through it and then sign it when you're done reading through it.
Judge, it might be easier for me to establish the basis.
Okay. Reading through his advice rights, and then I'll go through them with him.
Okay, what a sign right here. Oh, there.
Okay, so I've received back the advice rights, so I'm gonna go through them on the record with you as well, okay? So raise your right hand, Mr. Knobloch. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, and can you put your hand down, and I just need you to speak up a little bit louder. So you are Daniel Mark Knobloch.
Yes.
All right, so Mr. Knobloch, you have heard the statement of your attorney and the prosecutor and myself. Is it your intention today to plead guilty to count 2 domestic violence first degree, which carries a maximum penalty of up to 93 days in jail and a $500 fine with a Cobb's to no upfront jail because people had no position? And then that would be under the deferred statute. So if you successfully complete probation, it won't stay on your permanent record. Do you understand that?
Do I have to plead guilty or no contest?
Mr. Glazier, what are we doing?
It might be easier as a no contest, Your Honor.
Mr. Sneed, any position?
No, thank you.
Okay, so your attorney is asking you to plead no contest. So is it your intention to plead no contest to that?
Yes.
Okay,
Yes.
and you understand count 1 will be dismissed, which is the assault with intent. Do you understand that?
Yes.
Okay, now, are you satisfied with Mr. Glazier as your attorney and the advice that he has given you?
Yes.
All right, and neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Glazier?
That's correct, Your Honor.
Mr. Sneed?
Yes, Your Honor.
And Mr. Knobloch, to your knowledge, is that correct?
Yes.
All right, so if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. So do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you had been convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right? So by pleading, you have to apply to the Court of Appeals in the Supreme Court for an appeal. You don't get an automatic right like you would at trial. Do you understand that?
Yes.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court would not be bound by any sentencing agreement or evaluation, and you would not have a right to withdraw your plea. Misconduct is defined to include, but not limited to, absconding, failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions, sir, about the rights that I've given to you?
No.
Okay, so your response to my next question will be no contest or not guilty, okay? So how do you wish to plead to the charge that on or about June 18 of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense of domestic violence? No contest or not guilty?
No
Do you want to
contest.
sit down? Would you like to sit down? I'm sorry. It's okay. There's a tissue box there and you have a seat. Miss Adams, could you call for Claude Howard from the jail, please? Okay, so take a deep breath. You're gonna be okay. And when you're ready, we'll proceed, okay?
Good.
Okay,
Okay.
okay, tell me when you're ready. Okay.
I don't know.
If you need a minute, I'm fine with that. Do you want a minute, just a minute, or are you ready to continue?
I'm ready.
Okay, so your attorney said that you're gonna plead no contest.
Okay.
So my question is, how do you want to plead to the charge that on or about June 18 of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense of domestic violence? So no contest or not guilty?
There's no contest.
Okay, okay. Has anyone made any threats or promises to you to induce you to plead no contest to this charge?
Yes or no?
Not really.
Not really? Okay. So we talked about what your sentence would be in the deferred, but he hasn't promised you what you'll have to pay in fines and costs or anything like that.
He told me what it might be,
Okay,
what it might be.
okay, okay. But you understand I set the sentence, right?
Huh?
You understand that I determine what the sentence is, correct?
Yes.
Okay, all right. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats? Wait, I think I already did that. Did I already did that? No, I didn't. Do you understand if I accept the plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or it was not your own choice to enter the plea. So this is your choice to enter the plea, right?
Yes,
Okay, and you're doing this of your own free will, right?
yes,
Okay. Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier,
No, Your Honor.
Mr. Sneed,
No, Your Honor.
and is it your own choice to plead guilty? Or no contest, I mean?
yes,
Okay, so, Mr. Glazier, you said you wanted to place a factual basis on the record?
Yeah, it might be easier. Mr. Noblock, you've come in to talk to me about this at least 2 or 3 times in my office. Is that right?
yes,
And
think so.
and the last and the last time we were in here, I told you they had offered you a misdemeanor deferred with no upfront jail, and you wanted to take that deal rather than go to trial. Is that correct?
Yes, yes,
And we actually had an exam on this, and you heard what's her name? Amanda Wilson testify at that trial under oath, or at the exam under oath. Is that correct?
I never heard her, no.
Were you at the
What?
preliminary exam? Do you have a hearing downstairs where they took testimony? Okay, do you remember being, all right, so I have paperwork shows that you held a preliminary exam, your attorney questioned witnesses, and so did the prosecutor way back in the summer in August of 25. Do you remember going to court in August and the judge hearing testimony and you sitting with Mr. Glazier? Mr. Glazier, I think that if you and Mr. Sneed stipulate to the, for
That's
purposes of a no contest plea, Mr. Sneed, would you stipulate to him using the preliminary exam transcript and the police reports?
Yes, thank you, Your Honor.
All right, so, Mr.
Your Honor, we would just stipulate that at the exam, that the victim, and again, I forget her name, Amanda Wilson did testify that there was an argument. My client was moving out. They had been in a relationship, and he was going to leave, and that she says that there was a physical altercation, that he choked her. I just want to put on record, my client denies that, but for purposes of taking this plea on a no contest, we would ask the court to accept that testimony.
And based on the statements by Mr. Knoblaw, I would say it'd be for lack of memory, Mr. Glazier.
That and lack of memory, as well as the potential for civil liability.
All right, Mr. Sneed, anything to add?
I would just add, she further testified that 2 days later that the defendant had grabbed her aggressively on her upper right arm, and that led to 2 small bruises being observed on the victim's arm, based upon him grabbing and pinching her arm.
All right, so based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on June 18 of 2025, in the city of Adrian and the county of Lenawee, that the defendant did commit the offense of domestic violence by choking and then grabbing the arm of the victim, in this case, Amanda Wilson, leaving bruises, which satisfies the requirements. The court does find that the defendant did commit the offense of domestic violence and accepts the no contest plea. Ms. Adams, I'll need a notice of hearing from Mr. Knoblaw for sentencing on March 20. All right, at 8:15. So I accept Mr. Sneed, has court complied with MCR 6.302 B, C, and D.
Yes, thank you, Your Honor.
Mr. Glazier?
Yes, Your Honor.
As I said, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the Cobb's to no upfront jail based on the people having no position, the court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. Miss Adams, could you write on that notice from Mr. Knoblaw that he needs to report to district court probation on February 12 between 8 and 10 a.m. on the first floor?
Yes.
Okay, so I'm going to refer this matter to Mr. Knoblaw. I'm going to refer this matter to the district court probation department for a pre-sentence investigation, okay? Because it's a misdemeanor, the district court probation department will do that pre-sentence report, okay?
Okay.
When you go there, February 12th, next Thursday, a week from tomorrow, it'll be on the first floor of probation between 8 and 10. You're gonna go there and they're gonna set up a time or they'll meet with you that day. Be truthful with them about your background, but you don't have to say anything about this offense because you pled no contest, okay? They'll prepare a pre-sentence report. We'll provide it to Mr. Glazier. I think he mails them out to you, but if you need to talk to him, make sure you call him in advance of that, okay? And then I'm gonna set sentencing on March 20 at 8:15 in the morning. So Mr. Knoblaw, do you want to come in person or do you want to Zoom in?
Mr. Knoblow, maybe you want to do it here at my office. If you want to come here at the office, we'll Zoom and do it right here from the office. Would that be good?
Yes. Yes.
Okay, so on that March 20, you go see John Glazier at 8 o'clock in the morning and you'll Zoom from his office for sentencing, okay?
Okay.
So my staff is gonna bring you, stay right there. They're gonna bring you a notice of hearing for sentencing. And then on it will be instructions for you to report to the probation department, all right?
Okay.
All right, so we are all set. And I have the advice of rights on them already, Mr. Glazier, so that's good. And you just stay right there. And when my assistant brings you the notice, you can leave then, okay?
Okay.
All right, thank you. All right,
Thank you,
hold on,
Mr.
Mr.
Knobloch.
Glazier. I have the jail and I have Chelsea Miller in the courtroom. Mr. Glazier, is Chelsea Miller in jail or prison or?
I didn't handle this.
Oh, hold on. I got a note. All right, so in the matter of the people of the state of Michigan versus Chelsea Lee Miller, 2 files, 25-22425 FH and 25-22424 FH. Mr. Coast has her on testing. She's testing at Abbott Health in Jackson. She tested positive for marijuana on January 26th, but her February 2nd test was negative. Cocaine was her major issue. So she is not here. Do you want to try reaching out to her?
I can, Your Honor. I would just note, I've only met her one time, and that was at the pre-exam when we waived it. And actually the last court date, November 12th, you issued a bench warrant because she didn't show up on that date. I do have a phone number, I think, and I'll try to call her.
Okay, you go ahead and try to call her. All right. Mr. Daly, did you get the complaint for bond violation on your client?
Yes, Your Honor.
Okay, let me grab his file because he is logged into Zoom from the jail. So this is in the matter of the people of the state of Michigan versus Claude Jalen Howard III, file number 25-22458FH. I have James Daly appearing on behalf of Mr. Howard. So Mr. Daly, Mr. Howard is charged with controlled substance delivery, manufacture of marijuana, second offense, which carries a mandatory or a maximum penalty of up to 8 years in prison, as well as a police officer fleeing third degree, which carries a maximum penalty of up to 5 years in prison. I received a telephone call from pretrial services yesterday stating that Mr. Howard, so it sounds like he has potentially new charges.
Yes, Your Honor.
So he was arrested for delivery and manufacture of marijuana on February 3rd by the Lenawee County Sheriff's Department. The Sheriff's Department had him on a stop where they located approximately a pound of marijuana, $2,000 in cash, and 2 cell phones. So those are violations of his bond conditions allegedly. And so he is here today on a contempt of court on those allegations of violation of bond conditions. And you are aware, oh, and a DWLS. Okay, so I'm assuming you're gonna enter a plea of not guilty on behalf of your client today.
I am, Your Honor, but I would like to explain what's going on there. Mr. Howard's got a multitude of problems. I'm trying to put them all together and deal with those. These problems are going to result in a prison sentence. Now, even though it's going to do that, he needs some assistance in a lot of areas as it relates to rehabilitation. And that's available at different places that we could utilize in the future. But right now, I just want to get everything together and take care of that. There's not going to be a trial on this. He's going to plead guilty to this, but I'm trying to just put together a global resolution and get it over at once.
Okay.
If the court wants me to enter a guilty plea to the BOP today, I will do that.
Well, I don't want to enter a guilty plea on the violation of bond conditions because that would be an admission of guilt on these new pending charges, correct? So I don't think he's been arraigned on the new charges yet, has he? Mr. Howard, have you been arraigned on any new charges yet?
No, I have not, Your Honor.
All right, Mr. Coast, do you have any updated information on that?
I don't, Judge. I did get the violation of bond condition sheet from the deputy. But no, I do not have any information on that. I don't know if they're submitting to the prosecutor, waiting on the warrant or what.
All right, so why don't I set this over to next Wednesday, Mr. Glazier, and see if we have any further information?
Okay.
And then we can see whether we need to set it out or maybe bound up or what. All right, so Mr. Howard, I'm going to enter a plea of not guilty on the contempt of court. Your bond is set in the amount of 75,000 cash as surety, based on the fact that these allegations involve the same criminal offense that you are currently on bond on. So we will see you back next Wednesday. So I'm going to set this for January 11 at 8:30 in the morning. February 11 at 8:30 in the morning. Mr. Glazier, if he does get arraigned and his date set out, you can request to move that if you wish, okay?
Your Honor, I'm not sure what case you're
Mr.
talking.
Daly, Mr. Daly, I meant. All right, I have a trial today and I got like attorneys coming in and I'm not sure who's on the trial. So February 11th at 8:30, we'll see you back, Mr. Howard. Thank you.
Thank you, Your Honor.
Thanks, Mr. Witt.
No.
Mr. Daly.
My
right.
question is the cash as surety, is that 75,000 straight or 75,000 10%?
It's cash surety, so you have to post to a bonding agency 10% or however they do it.
I'll get over to the jail and talk to you.
Okay. All right. Thank you,
I'm sorry,
Mr.
what was
Howard.
that?
You're all set.
I couldn't really hear what you said, but okay, thank you.
Oh, Mr. Daly said he'll get over to see ya.
Today.
Oh. All right, thank you.
Thank you. All right. Thanks, Mr. Daly. Thanks for helping the other gentleman too. All right. Mr. Glazier, were you able to reach Miss Elliott or no? Miss, what was her name? Chelsea Smith?
Miller, Judge. Chelsea Miller.
Chelsea Miller. Mr. Glazier, were you able to, you're muted. Were you able to reach Chelsea Miller?
I was not, Your Honor. I tried the phone number and I left a message. When I had tried it on the earlier date, it wasn't in service, but it's in service now. I left a message that she should get a hold of us or the court as soon as possible.
All right, Mr. Coast, are you there?
She's not in jail either. I checked the jail.
No. All right. Okay, well, let's see. We still have a bond. Let's see.
I think it's a pretrial and contempt of court because you issued a bench warrant for not showing back on November 12th.
Yeah, but I thought it was set aside. No, I released her on a PR bond on January 7.
Okay.
And She has been reporting to Darren Coast.
Okay,
So I'm gonna adjourn this because she wouldn't be reporting if she was gonna ditch us. So let me set this out to February 25 for pretrial. And Mr. Glazier, if you can do the stipend order to adjourn and then make sure she gets a copy mailed to her. Mr. Coast, are you there? All right. Yeah, he's, no. Oh,
Judge,
Mr.
I'm
Coast,
go ahead.
on Chelsea Miller, she didn't appear today, but it looks like she's been reporting and testing as required.
She is, Judge. She's testing over at AberHealth in Jackson. And so she has tested the last 3 times, and I know her last test was completely negative.
Okay.
If you'd like, I could try to contact her by phone.
Do you want Mr. Glazier? It sounds like Mr. Coast has an updated phone number that you don't have.
that's fine. The number I tried had a recording on it.
Oh, okay. I think I'll just
John,
send
is
it
that
out
the
to February.
554 number?
Nope.
Yeah, let me
You want-
try to give her a call and see if she can log in.
All right, go ahead and mute then. All right, Mr. Glazier, Jason Evans. Oh, he's here. So in the matter of the people of the state of Michigan versus Jason Evans, Mr. Evans is here in person. You can grab his file. Do you pronounce it Jason?
Jason.
Jason, okay. So this is file number 25-22496FH. I have John Glazier appearing on behalf of Mr. Evans, and I have Isaac Sneed appearing on behalf of the people. Says, see, it looks like it's a first pretrial in this matter. So Mr. Glazier, how would you like to proceed?
Your Honor, if I may address the court,
Yeah,
I believe Mr. Glaze is covering for Mr. Dagger Margosian, who's unavailable today.
he's sitting right here.
Oh,
Actually, I think it's the opposite. Mr. Margosian
okay.
handled it for me because I think what I'd ask Your Honor is is this an arraignment?
No, it's a pretrial.
Is there any way I can talk with Mr. Evans?
Of course. So Mr. Evans, my bailiff's gonna take you out to the hallway and help you connect to a Zoom device. I just want you to know Mr. Dagger Margosian looked a little traumatized there for a minute.
Sorry, Mike.
So he's gonna go zoom in from the hallway. Mr. Coast is not responding. Has there been a plea offer? Well, wait.
On
Mr.
this
Hartung,
case?
who are you? No, hold on, I'll wait till he zooms in. Mr. Hartung, what are you hearing?
Yeah, Elliot.
Who?
Jeff Elliott. I think his name is Jeff.
Oh, yeah, there it is. All right, got the hallway. So Mr. Glazier, I'm gonna let him in. All right, so, Mr. Evans, go ahead and unmute your device. There you go, perfect. All right, I'm gonna open up a breakout room and I'm gonna put you and your attorney into that breakout room. Before I do that, what is the plea offer in this file, Mr. Sneed or Mr. Glazier?
Your Honor, the note I had, I didn't write it in here, but it says CCW, but there's no CCW on the information.
Well, yeah, it would be an amended information, I'm sure. So carrying a concealed weapon is a 5-year. How many, is that a 2-year? What is it?
5-year.
All right,
No
so,
upfront jail.
All right, Mr. Sneed, do you have anything written down?
I do. The offer, I discussed this with Mr. Dagger Margosian back in December. It was an added count of CCW. There's a potential for HIDA, I believe, with this defendant.
Oh, yeah.
We had offered 365 days suspended with agreement to no MDOC.
Okay, so the plea offer is plead to an added count of carrying a concealed weapon, which is eligible for HIDA. That's why that's being offered. So that would be added as a count for no upfront jail under the Homes Youthful Training Act. How old are you, Mr. Evans?
I'm 24.
Okay, so he's eligible with your approval then, Mr. Sneed?
Yes, I know he has some other cases, however, so I can't
All right, so if
confirm
those
whether or
other
not he's
cases
100%
don't,
eligible or not.
yeah, so if he would be eligible, it could be under HIDA and no upfront jail. All right, I'm gonna open up that breakout room now, and Mr. Evans, you're gonna get an invitation to join, and when you get that invitation, join the breakout room, speak with your attorney, and then when you're done, just come back in the courtroom, leave the device hooked up, because I'll probably need it again.
Okay.
There you go. All right, you doing all right, Mr. Burke? Okay, she's probably finishing up down there now. All right. There. All right, Mr. Coast, were you able to reach Miss Miller at all? You're muted.
Judge, I did reach a contact person for her and I did relay the Zoom number. So hopefully he could get a hold of her so she could Zoom on.
So we'll see if she shows up. Okay. Ms. Spade, I'm just gonna put the waiver of arraignments on. So in the matter of the people of the state of Michigan versus Christopher Cundiff, file number 26-22526FH, arraignment was waived. In the matter of people of the state of Michigan versus Robert Warren Ham, file number 26-22523FH, arraignment was waived. Both files, I'm sorry, 26-22524 as well. In the matter of people of the state of Michigan versus Andrew Coleman Lambert Jr., file number 26-22534FC, arraignment was waived. In the matter of the people of the state of Michigan versus Zachary David Rosenberg, file number 26-22525FH, arraignment was waived. No dates have been set yet. That one. I have the file for Elliot, Miss Spade, but did you have it on the docket?
I have several, Judge.
There it is. I see it 4.
Okay.
No. That's Sam. I don't know where Sam is. Probably in front of Judge O.
I was just over there. He's over there. That fellow, Mr. Elliott has a attorney general file as well as a criminal file.
Okay.
Actually, that's why Sarah's on the screen.
So Miss Brenner, we have jury selection for a murder trial going on next door. And so we're in like week 2 of jury selection. So the attorney has pretty much gone down there first. So that Judge Olsaver starts back up at 10:30 this morning. So
okay, I'm here whenever, Judge. I know both of mine are going to be adjournment requests, so I'm here when they're ready.
All right. If that's true, if you need to go, just go ahead and we'll make sure you get notice of the next date.
Okay, thank you.
You're welcome. All right. I lost John Glazier. Yeah. Oh, he's in the breakout. Okay.
So, okay.
Yeah, he's out in the hallway. So I'm gonna bring Mr. Glazier back, make him come back. All right, Mr. Glazier, we had a chance to speak with Mr. Evans then.
I did, Your Honor, and also Mr. Margosian did, so I think we've got it cleared up on what it's supposed to be.
Okay, so what would you like to do today?
He is going to plead guilty to an added count for CCW with the understanding he would get HIDA if he qualifies, and we firmly believe he qualifies. He's the right age, and CCW is one that he can get HIDA on. There would be a 1 year suspended jail, counts 1, 2, and 3, and the habitual would be dismissed. And I think that's a complete agreement.
Okay, so we're gonna head down to an advice of rights form. And so I want you to read through it and then I'll go through it on the record as well, okay? So while he's reading that, Mr. Glazier, is Mr. Rosencrans going to be a plea or set for another pre-trial?
I think it's going to be a plea, but I'll need to talk with him.
Okay,
I didn't pull up his file yet.
okay. Mr. Rosencrans will be with you next, okay?
Judge, could we pass over Evan so I can prepare a written fee agreement? Correct. Plea agreement.
So I have a trial starting in a half hour. Can you just get me that today?
Yes, I will.
Okay, because I still got like a huge list of people to go through. Did you need a plea agreement on Evans and Rosencrans?
I was just referring to Evans.
Okay. So Mr. Evans, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, so you're kind of soft-spoken, so make sure you speak loud for me, okay?
Yes.
Okay, good. So, Mr. Evans, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention today to plead guilty to an added count of carrying a concealed weapon, which carries a maximum penalty of up to 5 years in prison, with an agreement that if you're eligible for the Homes Youth Training Act, we'll send you under that there will be 1 year of jail deferred. So there'll be no upfront jail, but if you violate probation, you're gonna do a year in jail. And then you understand if you're eligible for HIDA, that means that it won't go on your permanent record.
Yes.
Okay, now it's my understanding you have some other stuff going on, and I'm not sure if that'll interfere with your eligibility, but we'll figure that out.
I'm confused on the other stuff that I got going on because
Well, we'll figure that out, okay? All right, so is it your intention then to plead guilty to that added count 4 of carrying a concealed weapon?
Yes.
And that does require mandatory forfeiture of the weapon, is that correct, Mr. Sneed?
Yes.
Any other requirements, Mr. Sneed? And I know you're doing the plea agreement, but.
No other requirements, Judge. Thanks.
Okay, so are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
Yes.
And neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Glazier?
That's correct, Your Honor.
Mr. Sneed?
That's correct.
And Mr. Evans, other than what was placed on the record, there's been no discussion with me about anything else. Is that correct?
Yes.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
All right. Do you understand that if the plea is accepted and you engage in any misconduct as defined by MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding, failing to appear for sentencing, violating your terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So if you weren't to show up for sentencing, or you were to violate bond conditions or get charged with a new offense, I wouldn't be bound by this plea agreement. I could give you a year in jail. Do you understand?
Yes.
Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No.
All right. So how do you wish to plead to the charge that on or about October 1 of 2025 in the city of Adrian, the county of Lenawee, that you did commit the offense under count 4, carrying a concealed weapon? Guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during the hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
So we did put a pretty comprehensive agreement on the record, but other than that, has your attorney promised you anything else regarding your sentence?
No.
Okay. Is it your own choice to plead guilty?
Yes.
Okay. So on October 1 of 2025, we're in the city of Adrian in the county of Lenawee. On October 1 of 2025, we're in the city of Adrian.
Yes.
Would you agree that's in the county of Lenawee?
Yes.
Okay. Do you have a carrying a concealed pistol license?
No.
So you have no legal right to carry a concealed weapon. Is that correct?
Yes.
All right. So did you have a weapon at that time, a pneumatic gun that was concealed in some way, like in your coat, under your seat? Where was it?
It was in the car.
Okay. Are you satisfied, Mr. Sneed? Where was it in the car?
I grabbed it from under the seat.
It was under the seat. Are you satisfied, Mr. Sneed?
I am. Thank you.
All right. Has court complied with the MCR 6.302 B, C, and D? Mr. Glazier?
Yes, Your Honor.
Mr. Sneed?
Yes.
Ms. Adams, could I also get a notice of hearing for sentencing March 20 at 8:15? When we come for sentencing, you want to come in person or via Zoom?
Person.
All right, it'll be in person, Ms. Adams. Thank you. All right, I accept the plea. It has been given understandably, voluntarily, and accurately. He has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case, but the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew agreement that was placed on the record. I'm going to refer this matter to the probation department for a pre-sentence investigation. We will set sentencing on March 20 at 8:15 in the morning in person. So what I'm gonna do is have you walk, well, I'm gonna get you a notice of hearing, and then I'm gonna have you walk across the hall to the probation department and check in. They're gonna give you a date and time, probably a packet to fill out, a date and time to come back and meet with them, and also get your contact information. When you meet with them, be truthful about your background, the events that occurred. They'll prepare a pre-sentence report. We will provide a copy to Mr. Glazier. He will review that with you before the day of sentencing. So call his office, set up a time to meet with him and talk to him about it, okay?
Okay.
And then we will see you back on March 20 at 8:15 for sentencing. So you're gonna have a seat here. I'm gonna get you a notice of hearing, and then you're gonna go check in right across the hall at the probation department, all right?
Okay.
All right, thank you.
Thank you.
Nice. All right, well, then, Mr. Rosencrans, I'm gonna take you next. All right, just step across the hall, okay?
Okay.
Thank you.
Thank you.
Yes, good manners. He pushed the chair in. Even attorneys don't push chairs in. All right, so Mr. Rosencrans, let me grab your file. Miss Underwood, I believe you represent Mr. Pegues.
Yes.
He is in the building in lockup.
Oh.
I know.
Okay.
All right, so this is in the matter of the people of the state of Michigan versus Craig Barrett Rosencrans. We have two files, 25-22459FH, 25-22460FH. I have John Glazier appearing on behalf of Mr. Rosencrans. This is the date and time set for pretrial. Mr. Glazier, how do you wish to proceed?
Your Honor, he's gonna plead guilty to count one with the other understanding that the other 5 counts and the other file would be dismissed. I don't remember if count one's forgery or UMP. It's one of those.
So he's gonna plead guilty to count one on file number 25-22460.
Okay.
I don't know, you didn't tell me. So there's uttering and publishing on 2246.
That's the file. Because the other one's financial transaction device.
Yep. All right, so he's gonna plead guilty to count one, uttering and publishing, which carries a maximum penalty of up to 14 years in prison along with restitution. All right, and then file number 25-22459 will be dismissed at the time of sentencing. Is there any restitution that will carry over?
I'm not aware, but if there is, he knows he'll be ordered to pay restitution.
There was a written plea agreement. I wonder if that's been reviewed and signed.
Mr. Sneed, are you able to email that to me? It's probably in the clerk's office. I don't.
Yeah, I will, Judge. Thanks.
Hold on one second.
Judge, Mr. Rosencrans also has been accepted into drug court, is my understanding. And
yes, he has.
Okay.
I think he's been in contact.
He was actually in a program and got out to take care of this. I don't know if he's back in that program or not.
He's back in the program. Yeah, you're there right now, aren't you, Mr. Rosencrans? Yes. I can tell by the room he's in. All right, Mr. Sneed's gonna email me that plea agreement form. Mr. Igelli. Mr. Malaro, what are you doing with Mr. Iagully today?
Judge, Mr. Aguli brought me a bunch of information.
Hold on, let me call the case. If you're just gonna get another date, let me call it so he can get on his way. He's gotta go to
I'd
work.
like to.
All right, and I appreciate you guys all had to take care of Judge Olsaver's court first. I'm not saying that in any snarky way. I just meant he's wearing his safety work clothes. So in the matter of the people of the state of Michigan versus Angelo Craig Iagully, file number 25-22412 FH. And Ms. Adams, I'll need a pretrial notice for Mr. Iagully. This is the date and time set for pretrial, and Mr. Malaro is present on behalf of them. I have Isaac Sneed on behalf of the people. How far of an adjournment do you need, Mr. Malaro?
Not more than 30 days, Judge. He brought me some information. I got to get a hold of Deputy.
So Ms.
Spielman
Adams, can I get a
to-
notice for March 4 at 8:30? Right, so that's great. Mr. Malaro, March 4 at 8:30 in the morning.
Yeah, that's good.
All right, have a seat right there, Mr. Iagully. We'll get you a notice of hearing and you can be on your way, all right?
Thank you.
You won't need to do the notice. All right, Mr. Sneed very kindly has emailed me the plea agreement form for Mr. Rosencrantz. Let me print that off.
Yeah, Judge, if I could address
Sure,
it, that appears to just be the plea for file ending 5/9 FH. I don't see any terms of an agreement for 6/0 FH or an agreement that case would be dismissed. So we may need to adjourn to address all of that, because I believe there is also what's noted as substantial restitution at 6/0 FH of about $17,000.
Hold on, everybody. We're getting like a lot of noise and I don't know where we're picking it up from. All right, so the plea agreement that Mr. Sneed has sent is for file number 25-22459 FH with restitution of $270. Kenneth reading, no objection to recovery court. That is not the file that perhaps Mr. Glazier, the newest plea offer, is on, because you said the uttering and publishing on 22-460. Who's your prosecutor on this one?
That's just the notes I have. It was Alex Bayanetto.
If you want to take a minute to call Mr. Bayanetto,
I can, but that's what I wrote
or
down.
I can set it for another date.
I'll try calling Alex.
Okay, go ahead and mute yourself and try that. Okay, thank you, Mr. Iagully.
Thank you.
All right, Miss Underwood, Mr. Burke has been here this morning and he's been so patient with me. So let me grab his file. In the matter of the people of the state of Michigan versus Jamie Burke, file number 23-21220 FH, and Rhonda Underwood appearing on behalf of Mr. Burke. This is the date and time scheduled for hearing. He is appearing from Washtenaw County on this probation violation. So, how would
Can
you
I have
like
a
to
breakout
proceed?
with Mr. Burke, Your Honor?
Yep. So Mr. Burke, I'm gonna open up a breakout room and you, if you're on a Polycom, you may go automatically, all right? If you're not on a Polycom, they might need to make you join, so we'll see what happens.
I have to join.
Yeah, you gotta go get them. But Mr. Burke, I can bring you back in. So once Rhonda comes back, I'll bring you back in. You won't need them for that, all right?
Thank you. Thank you, Your Honor.
You're welcome. All right, let's see. Ryan Bates is in my waiting room. Oops. Brenda, I do have Miss Brenner on Bates, if you want to take, where'd she go? She's already gone. Okay.
He's
Never
in a
mind, I lost
breakout,
her.
Judge.
Yeah, but she went faster than I thought she would. All right, Mr. Bates will be with you in just a moment, all right?
Yes, Your Honor. Thank you.
Okay. right, we got Burke. All right, we got Rosencrans. Mr. Glazier, just let me know on Rosencrans when you're ready.
I can't get a hold of Mr. Bayonato, so that was my understanding was the plea and the other file was dismissed, but
You know, I think he's got a jury trial with me. Who's your,
He's on this case. Alex is on this case, so I imagine
our trial?
Yeah.
So he might be,
he's not across the hall, he's here. I mean, he's don't.
he's not here,
15.
but we can go snatch him if we can find him. You text him?
Sure.
Tell him it's on Rosencrans. Thank you. All right, Foster. All right, Daniel Foster, why don't you come up to the podium? All right, Mr. Malaro, I do have Daniel Foster. Grab this paper. All right, in the matter of the people of the state of Michigan versus Daniel Allen Foster, file number 25-22501FH. I have Salvatore Malaro appearing on behalf of Mr. Foster. Mr. Bayonato, we need you to verify the plea offer on Craig Rosencrans. So I'll give you a minute to do that. All right, so Mr. Malaro represents Mr. Foster. I have Isaac Sneed appearing on behalf of the people. This is date time set for a first pretrial in this matter. Mr. Malaro, how would you like to proceed with Mr. Foster?
Judge, what I'd like to do is adjourn this matter to talk to Mr. Foster and see what kind of resolution we can reach on this matter.
Right, 30 days, okay?
Yeah, 30 days should be fine.
All right, Ms. Adams, could I get a notice of hearing from Mr. Foster for pretrial on March 4 at 8:30 in the morning? So, Mr. Foster, we did give you Zoom instructions.
Yes.
Okay, so make an appointment to talk to Mr. Malaro before we come back, and then we'll get you a notice of hearing. If you want to just have a seat right behind you, we'll get you that notice of hearing and we'll see you back on that day, and you can Zoom in.
Okay.
Okay, all right, thank you. We'll get him that notice on that one. All right, hold on one second. So, Ms. Underwood, Mr. Burke, how would you like to proceed with Mr. Burke?
Your Honor, Mr. Burke is awaiting sentencing on his district court case in Ann Arbor. So I would ask for just one more adjournment, probably a week or two.
Okay.
If I
Mr.
may,
Burke, you've been waiting for sentencing for a long time. All right, how about?
if I may speak,
Yeah.
I actually have sentencing the 23rd of February, so it would
Okay.
have to be after that.
Okay.
All right, February 25 at 8:30 in the morning for Mr. Burke.
Great, Your Honor. Thank you.
All
Thank
right,
you
so
very
Mr.
much.
Burke, we're gonna set this over to February 25 at 8:30 in the morning. Ms. Underwood, if you can do the stip in order to adjourn. Mr. Sneed, can she sign your name with permission?
It's a violation of probation, I believe, Your
Oh,
Honor.
never mind. We'll do the notice of hearing then. So Mr. Burke is all set and my staff will get that request to have you brought over. Wait, thank you. All right, so Mr. Burke, you are all set now. Thank you.
Thank you very much,
Your
Your Honor.
Honor.
I hope you have a good day.
Ms.
Hold on, yep, hold on, Rhonda. Can you take care of Mr. Bates so Ms. Brenner can go on her way? Mr. Burke, you're all good. All right, so Ms. Brenner, I think, do you have another one with me or is Bates the only one?
I have Bates and I have Elliot with Sam.
Okay, in the matter of the people of the state of Michigan versus Ryan Matthew Bates, file number 25-22336FH. I have Sarah Brenner or Rhonda Underwood appearing on behalf of Mr. Bates and Sarah Brenner appearing on behalf of the Attorney General's office. So, Ms. Underwood and Ms. Brenner, how do we wish to proceed?
Your Honor, Mr. Bates is making regular payments. He did have a misstep last month, Your Honor, but I think he's back on track. I've spoken with Ms. Brenner, and probably a 60-day adjournment is indicated, and I will be happy to do this stip in order.
No objection, Your
60
Honor.
days, okay. How about, March 8th, how about March 18?
That's fine.
Okay, I'll set a pretrial for March 18, and Ms. Underwood, can you do the stipend order to adjourn to March 18 at 8:15 in the morning?
Thank you.
Thank you.
What
You may sign with my permission. Donna. Thank you.
Okay, so that takes care of Mr. Bates. Mr. Bates, you are
Can
all
I-
set. March. Yeah,
Can I add one thing though?
sure,
I'm
maybe,
trying-
yeah.
I'm just trying to find out how I missed a payment and when it always comes out of my checks.
It was just a little less, so you must have just started the job or something. It was just a little short last month.
Oh, no, I ended up in the hospital. I thought my gallbladder was bled, but it found out it was just inflamed, so they didn't do the surgery. So
Yep, you're all
that's
good,
all I was
Mr. Bates.
wondering.
You're making your payments. You're doing a good job, so keep it up, okay?
Okay, thank you very much, and you all have a good day.
Oh, and file your taxes so we can intercept that return too, because that'll help you out a lot.
Oh, I know. I planned on it.
Okay, good. Thank you.
Thank you.
All right. All right,
Bye.
so now we're gonna go back to Mr. Rosencrantz. Mr. Rosencrantz is represented by John Glazier. So I have a plea agreement, Mr. Bandetto, that is written that says the plea is to count one, a financial transaction charge on 25-22459
No.
FH.
That should
But
be a,
Mr. Glazier, hold on, Mr. Glazier, let me
You're not-
finish. Don't interrupt me.
okay,
Don't
you're
interrupt
not saying it right though.
But Mr. Glazier said, to his understanding, the plea offer was to plead to count one on file number 25-22460 FH, which was an uttering and publishing, and mid-offer sentencing and restitution. Count two would be dismissed on that one, as well as the counts on 25-22459.
I never discussed that with Ms. McClure, Your Honor. I'm not sure where Mr. Glazier got that. I was not aware of
Okay,
that.
so I'm gonna adjourn this so that Mr. Glazier, you can follow up and verify what that is. Mr. Rosencrantz, I'm gonna try to set this as soon as possible. So it looks like I can set this over 2 weeks to February 18, Mr. Glazier. Would that give you enough time?
Yep. And is this your case, Alex, or is it hers?
Ms. McClure has the uttering and publishing case. I have the financial transaction device case.
Okay.
So you may have, yeah, so it may just be, Ms. McClure has the uttering and publishing.
Yes.
Okay, so maybe you got a plea offer from both of them, Mr. Glazier. All right,
Yeah.
so Mr. Rosencrantz, keep up the good work.
What's
And
the
we'll
date?
see you back February 18 at 8:30 in the morning. All right, Craig?
Okay, thank you.
Thank you. All right, okay,
February
18 at 8:30 in the morning.
of February?
February 18, 2 weeks from now.
Okay, thank you, Judge.
All right, so, hold on one second. So the two of you came in, what case are you here for? Yeah,
Upon reduction hearing, Rudy Perez.
okay. All right,
Last time, you came in just two.
all right. So, Mr. Malaro? Jeff
Yes,
Elliott?
Your Honor. I'm here.
Okay. He's not in jail.
Who are we looking for?
Elliot.
Jeff Elliott?
Oh, yeah, he was in my the waiting room in my office, but he got really nervous about, he said he had the drug test by 11, so I told him go ahead. I can go check and see if he's back.
It's only 10:20.
I don't know where he's got a drug test, Judge. So let me see if he came back yet.
Okay. Thank you. All right, so let's go to Mr. Coast, circling back to Chelsea Miller. I haven't heard from her, have you?
I have not, Judge. I did leave that message and he was going to try to contact her, but no, I have not heard anything more.
All right, so Mr. Glazier, Miss Miller appears to have failed to appear again. Do you have anything you want to add?
No, Your Honor, I left a message on her phone and I haven't talked with her since October.
Okay, I'm gonna issue a bench warrant for failure to appear on both the files. Mr. Coast or Mr. Glazier, if you hear from her, let me know, because I don't sign this warrant for 48 hours and we can just reschedule it. I'll set bond in amount of 25,000 cash as surety on each file.
All right.
Okay, so we call the jail. Hey, this is Judge Anselm. So I am ready on Israel Vela. Oh, wait, and it's Timothy Neves in person.
Yeah, he's in person.
Okay, never mind. I'm ready on Israel Vela.
Yeah, that's your bench trial.
And not Neve yet?
No, well, no, he's here already, so.
Okay, great.
Okay, all right, he's my trial today. All right, thank you.
Yep, no problem. Bye.
Bye.
Judge, I found Mr. Elliott.
Okay. All right, is he with you?
Yes.
Awesome. All right, this is in the matter of the people of the state of Michigan versus Jeffrey Allen Elliott. File number 21-20212FH, 23-21200FH, 25-22203FH. All of those files, we have Douglas, right, Hartung?
No, I just have the drug case.
Oh, Isaac Sneed appearing on file number 22203, and then you're on the other two, other than the one Ms. Brenner is on?
Let's hope so.
The CSC and the truck.
No, I'm not on the CSC case. I'm on the meth case.
I'm so confused. Okay,
And I'm on 21-200.
Yeah,
That's
I got two child support failure to, okay, so let me stop. On file number 21-20212FH, it's a probation violation on a CSC case with Salvatore Milaro appearing on behalf of Mr. Elliott. On file number 23-21200FH, probation violation pretrial with Salvatore Milaro appeering on behalf of Mr. Elliott, and I have Sarah Brenner appearing on behalf of the AG's office. Then I have a new file, 25-22203FH with Salvatore Milaro appearing on behalf of Mr. Elliott, and I have Douglas Hartung, right? Appearing on behalf of the people on that file, which is the methamphetamine case.
That's not a new file, but yes, I'm on that file.
It's not a new file? I thought it was Bob. Is it Bob? No.
No, it's an active new file, yeah.
Yeah. Okay. And then I have file number 25-22204FH, which is a pretrial again on a new file. I have Salvatore Milaro appearing on behalf of Mr. Elliott and Sarah Brunner appearing on behalf of the AG. So Mr. Milaro is present with his client in his office. You have a notice from Darren Coast stating that Mr. Elliott is one of his best drug testers. He doesn't miss and he is always completely negative. So that is awesome. So I guess Mr. Milaro, how do you want to proceed on all of these today?
Well, what I'd like, judges, for them all to be dismissed, but I know that won't happen since all these prosecutors are ganging up on me. But I would ask to adjourn the matter. He's currently working, currently paying, and I'd like to perhaps carve out some time to talk to Mr. Hartung about seeing what we can do to ameliorate any type of issues so that he can continue to work and pay his support order. That's the reason for my adjournment request, Judge.
Mr. Hartung?
I have no objection.
Ms. Brenner, is he making payments?
Yes, Judge, he is. So I have no objection either.
All right. How far out would you like these adjourned, Mr. Milaro?
Maybe 6 weeks, Judge?
All right. So April 1 at 8:30 in the morning.
That's fine, thank you.
So we'll do the notice of hearing for both violation of probation files. But Mr. Malaro on the 25-22203 and 04, we can do the step in order to adjourn. Mr. Hartung, can you sign your name with permission?
Sure.
Ms. Brenner, can you sign your name with permission?
Yes, Judge.
All right, excellent. So Mr. Elliott, keep up. Can I see him?
Yep.
Is he there? I see him.
Yeah, he's there. Yep.
Okay.
We saw him earlier, yes.
Okay. Well, good job, Mr. Elliott. Keep up the good work. Thank you.
Thank you, Judge.
Thank you. All right.
Thank you, Judge.
So it takes care of Mr. Elliott. There you go, Judge. Yep, I saw him. Must not have been looking when you showed me before. All right. Got the jail. I got Mr. Vila. Mr. Glazier, are you waiting for Gregory Bowers? And I know you have Rudy Perez, but in the matter of people of the state of Michigan versus Gregory Allen Bowers, file number 25-22231FH. I have John Glazier appearing on behalf of Mr. Bowers, and I have Isaac Sneed appearing on behalf of the people. According to the Oakland County Jail, they don't Zoom. So I'm going to ask our sheriff to contact their sheriff to see if we can, I don't know, have them transport, I don't know. So Mr. Glazier, I've never had a jail say they don't do it or not accommodate another court, because I can guarantee I won't be as accommodating of Oakland County next time. So we will,
Judge,
yeah.
their only option was for us to call in Polycom, and we can't do that with you on Zoom.
Yeah, so we can't Polycom them, they'd have to Polycom us. I don't understand how they can't bring a laptop or something, but, so, I don't know what to tell you, Mr. Glazier, on this one.
It would appear to me that a writ should be prepared and he should be brought in, but.
Mr. Sneed, any objection to that?
No objection.
All right, so how about we set another pretrial and we do a writ? Who would transport him? Our sheriff's department would, or the arresting agency, right?
Arresting agency would.
Yeah, the arresting agency would, according to my expert. So who's the arresting agency on this one? And we don't have prints anyway, so that helps me, City of Adrian. All right, so Mr. Sneed, can you prepare, will your office prepare a writ? And then I'll
Yes,
set this out to February 25 at 8:30 in the morning.
February what?
And February 25 at 8:30 in the morning, and you can do the step in order to adjourn, Mr. Glazier. And Mr. Sneed, can you sign your name with permission?
Yes, thank you.
And then Mr. Sneed's office will prepare a writ and we'll fingerprint them anyway, so that'll work. Okay. It would be easier just to take somebody's laptop in there and Zoom them, but okay. All right, so Mr. Glazier, then I'm gonna do one more pre-trial and then we have Mr. Perez, okay?
All right.
You're Rudy Perez?
Yes.
Okay, all right, so in the matter of the people of the state of Michigan versus Israel Vila Jr., we have two files, 25-22210FH, 25-22368FH. I have Salvatore Malaro. Are you with us, Mr. Malaro?
Yes, Your Honor, I'm ready.
Appearing on behalf of Mr. Vila, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pre-trial on both these files. So, Mr. Malaro, how would you like to proceed?
So, Judge, we had a bench conference with Miss Arnold some time ago, and some issues were discussed, and there was the formal plea offer and all that. I have not had an opportunity to go over to the jail and speak with Mr. Vila about that, but I can do that this afternoon since my 1 o'clock canceled. So I'd ask to adjourn this out maybe 30 days so I can talk to Mr. Vila this afternoon and then see what our next course of action would be with respect to these cases.
So I'll set this out for pretrial on March 4 at 8:30 in the morning. And Mr. Malaro, can you do the step in order to adjourn? And Ms. Arnold, can he sign your name with permission?
He certainly can.
Judge, it would be my
All right.
pleasure to do a step in order on these cases.
Okay, so Mr. Vila, we'll see you back on that day, okay?
I'll come see you
Thank
this afternoon, Israel.
You always say that, man. I ain't telling you that.
And I always do it, man. I always do it. He's my boy. What can I say?
All right, so that leaves Mr. Malaro. I have nothing else with you, right? Yeah, no.
I hope not, Judge. I hope not.
All right, and Rhonda Underwood must be on her way over to see Mr. Pegues. All right, so Mr. Perez, you want to come stand up at the podium for me, please?
Yeah.
Good, all right, let me grab, yep, right in front of you. Next, go to your left a little bit, go to your left, push open, there you go. All right. Okay, so this is in the matter of the people of the state of Michigan versus Rudy Mario Perez, file number 25-22457XC. I have John Glazier appearing on behalf of Mr. Perez, and I have Isaac Sneed appearing on behalf of the people, but I do see that Mr. McCready did file the response for the people, but obviously he is engaged with jury selection for the trial next door. So Mr. Sneed, I do have his response. Are you proceeding on this today?
I am, thank you.
All right, so Mr. Glazier, you can present your motion for bond reconsideration.
Yeah, yes, Your Honor. Mr. Perez has come into my office, I don't know, numerous times, 4 or 5 times. We're active in preparing this for trial. There's actually quite a bit of research that we're doing and getting witnesses around. But I would indicate that he had asked me if he could get the tether taken off. The tether is costing him $300 a month, and I think he only makes around 800. He can tell you exactly how much he makes. We would be acceptable to any other alternative. If you want him to report into the court daily or twice a week or 3 times a week at the clerk's office just to make sure he's staying here, you know, but he understands this is a serious charge, but you know, we're going to fight it at this point, but he just can't afford the tether.
All right, and so Mr. Sneed, obviously I know that you are covering on this, but in the response for the people, it says that are appropriate given the prior defendant's prior criminal record, and I don't have a habitual offender.
I can address that, Your Honor. At least in Michigan, is what all I have for CCH. He had a misdemeanor assault and battery in 92 and a domestic violence in 95. He's lived here all his life.
Okay. So no prior criminal sexual conduct. There are others.
There are other crimes out of the state of Texas.
Or any of them.
I would.
Okay, what are they?
There's a misdemeanor assault from 2010. There's a second misdemeanor assault from, let's see. (2021).
Oh, that's done.
In Michigan, there was a assault from 1992 that was dismissed. 1995 that was dismissed. Assault from 1995 that was pled down. Domestic violence second offense that was dismissed in 2002. In 2010, there was 2 counts of domestic violence second offense, both dismissed. And that's what I have for Michigan, Judge.
Okay, so his prior disputed or otherwise misdemeanor record, no prior criminal sexual conduct charges, as far as we're aware, though, no prior felons, correct?
Not that I'm aware, Judge.
All right, So, Mr. Glazier, you should be receiving your, well, actually, you've already received your preliminary examination transcript, is that correct?
Yes, I have.
Okay, is there anything else you want to add? You guys are pacing. You know I got a while before I start your trial. Why don't you two go in the jury room? If you want to have a coffee or something, because I've got like this and one other thing, and then I'll come talk to you. Is that all right? Okay. Anything else, Mr. Sneed?
Judge, I had a chance to review Mr. McCready's answer to the motion, and I would just reiterate the statements he made in that defendant's motion should be stricken, and the only factor cited is ability to pay for the tether, which I don't think is a factor under the court rule. Thank you.
All right, anything else, Mr. Glazier?
Your Honor, I believe ability to have the tether, it is something the court considered. The court is the one that issued the bond condition that he have a tether. As I've indicated, my client lives here, has lived here all of his life. He doesn't make enough money to have the tether. It's causing him serious problems, and he'll do anything. He'll come report daily if you want him to report daily to the clerk's office. Whatever alternative the court would order, he would follow.
All right, so in this case, the allegations underlying these offenses would have been in the date range of 2018 through 2020. I'm gonna guess the tether was ordered in district court.
I'm not sure, Your Honor.
Thank you, Mr. Gross. Not seeing any. Okay, so did you say, Mr. Glazier, you're ready to set dates on this one for a trial?
Yeah, I don't think our pretrial, hold on, our pretrial isn't until April 8th, and we're doing quite a bit of investigation in this. There's some witnesses down in Florida, that type of thing. Yeah, at this point, we're going to set it for a trial. And my client knows, he's well aware that if he gets convicted, Your Honor, that he'd probably spend the rest of his life in prison, given his age. He's aware of that. But, he's not going to run, Your Honor. His family's all here. He's been here all of his life.
Well, in this case, Mr. Perez is charged with 2 counts of criminal sexual conduct, second-degree person under 13. I'm sorry, 1 count of first-degree person under 13, which carries a maximum penalty of life with a mandatory minimum of 25 years. And the second count is second-degree person under 13, which carries 15 years. It's pretty typical that most people are in custody. Based on the nature of these charges, you were able to postpone and be released on a tether. I do feel, based on your prior record of assaultive charges, both in Texas and in Michigan, that does indicate the ability to travel. And I feel that the tether is appropriate in this case. If you want to pre-trial it, set a trial date now, I could do that.
No,
Mr. Glazier,
we'd rather leave it where it's at. We're still doing quite a bit of investing. This is an old allegation, Your Honor, and we're looking into certain things.
okay, all right, so I'm gonna leave the tether and deny your request for bond deduction. If you can do an order on that, Mr. Glazier, so you're gonna have to keep wearing the tether, okay?
Okay,
All right, thank you all.
thank you, Your Honor.
Thank you. All right, do you want to see if Brenda's down there with Mr. Pegues?
8578. Has Ms. Underwood talked to the MDOC and maybe yet? Is it talking, bringing down to the?
Yep. Okay, who are you here on?
I'm waiting for the next case.
Of the trial?
Yeah.
Are you a witness?
My daughter is.
8578.
Are you a witness?
No, my daughter is.
Okay.
When she's done, go ahead and bring it down. Yeah.
How are you?
How are you?
I'm here. Can't complain.
If we did, it wouldn't be anything.
No.
Where would you like him to sit? Rhonda, where do you want him?
He should be right here.
Okay.
Hmm?
Do you want him to stand there or?
He can wait over there.
Okay, all right.
Please rise, start personnel in session.
I'm here. Well,
Okay, be seated.
Mr. Pegues, go back up there with Miss Underwood for me, okay?
She was too quick for us.
No, I saw you walk by, so.
Okay.
I'm gonna pretend I didn't come in the courtroom and just stand. I'm sorry. That's okay.
No worries.
But I didn't start.
No, I'm proud of you. Thank you.
I'm gonna blame him, Doug. Tell me when you're ready.
Ready, Judge. Thank you.
Okay, so this is in the matter of the people of the state of Michigan versus Eugene Pegues, file number 25-22399FH. We are present with Rhonda Underwood appearing on behalf of Mr. Pegues, and I have Isaac Sneed appearing via Zoom for the prosecutor's office. This is the date and time set for a pretrial conference. So, Ms. Underwood, how would you like to proceed today?
Your Honor, I have spoken at length with Mr. Pegues. We have had a wonderful conversation. I believe the offer in this case, Your Honor, is a bifurcated offer. It's a choice. Mr. Pegues can either plead guilty to count one with one supplement, or he can plead guilty to, which would make it a, I believe, a 6.5 year, Your Honor, or he can plead guilty to both counts with no supplements, capping these matters at 5 years. I've spoken with Mr. Pegues. We've looked at
guidelines,
the guideline, the PRVs, Your Honor, and they don't change either way. They're still the same, even with the count, with the addition of the additional conviction. So I think probably the way for Mr. Pegues to go is the 2 counts with no subs.
So if he pleads to count one with 1 sub, it'll count as 1 felony if he gets in trouble again.
Right.
But if he pleads to the second one, count 1 and 2, then if he gets in trouble again, it'll be 2 felonies, but you said the guidelines were the same?
Well, the PRVs are the same because the 20 points still keeps them at an E.
Okay. Do we have the total guidelines on them now?
Mm-hmm.
What are his minimum sentencing guideline range? Have you tried?
It looks like it's going to be 12 to 24, but I'm guessing on the LVs.
Okay, Miss Adams, could you call Tom Moore? He logged off.
Yes.
All right, so what does your client want to do then? Plead to 1 with the sub or to both?
I believe it's kind of a choice between having 2 convictions and having a longer tail. But Mr. Pegues' out date is 2040 something. So he's not going anywhere for a long time anyway. So I'm
doesn't know how many prior, he has 1 prior felony. He has one prior felony for homicide out of Wayne County. He has no other felony convictions other than that one.
He has 2 priors.
I only show one. So Mr. Steen, I show you as one conviction for homicide in 2010.
I thought there was a, receiving stolen property.
Mr. Steen, are you able to view that, to see how many prior felonies he has?
Yes.
Thank you. Do you know Mr. Pease? I guess I could ask you.
Miss Judge, I don't think that receiving concealing stolen property is on the record because I was on HIDA probation.
HIDA. Okay,
But I
can you
didn't-
step up just a
I'm
little bit?
sorry. I didn't complete it, so I don't know.
Okay, got it. All right, so you might have,
It shows up on the biographical, in the prison biographical.
okay, and the only reason I was asking, because that does make a difference if he pleads to 2, but if he already has 2 prior felonies, it doesn't make a difference. See what I'm saying? So, let's see what Mr. Sneed shows.
So in the iChat, I don't see anything in the judicial segment for the receiving and concealing. There's just the charge segment and the arrest segment. So I can't tell from that.
That kind of
It
does
would
make a
count
big difference.
or not. And then it's not
Would-
on the, it's not on Otis either.
Does HIDA count for a habitual third?
I believe it does.
So it might already count anyway. So it's up to your client. He can plead to 1 count, which is a 7-year, or 2 5 years.
Which do you want to do? I'm sorry. We are a site gang waiting to happen.
The receiving and concealing stolen property is not on there. That's why it's a plea count 1, and then only have the 1 felony as a individual.
I don't think so. I think it's,
I roll with what you said.
this isn't my choice. I suppose.
John, if I could address the court while they're negotiating, the information only identifies him as a habitual offender, 2nd offense. So I believe we would stand by that.
Mr. Sneed could make this real easy if you just say count 1, no subs.
Well-
He's gonna be in prison till 2040. You want to just shoot count 1, no subs?
No.
Okay. So Ms. Underwood, a couple things. If you want to run the guidelines, I'll give you the guideline book. If he had HIDA, my understanding is, does HIDA count as a habitual? It doesn't, right? So right now, if he pleads to 1 count, that will give him 2 prior felonies if he ever gets in trouble again, right? 2. But if he pleads to count 1 with the sub, and then if he pleads to count 1 and 2, that'll give him more prior felonies if he ever gets in trouble again. I know the tail is the difference of 2.5 years, but 2040 is his release date, so I don't know. So if you want a minute to talk to him.
Well,
I know Mr.
Okay.
Dagger Margosian is kind of an expert on these.
You're gonna get out. Because this is probably been, I think he's probably been pretty good. You're gonna get out at that point. You're not gonna be an old man.
Hey, Tom Moore, if I give you an MDOC number, can you look someone up for me?
Yes.
MDOC number
Go ahead.
738-552. It's Mr.
Eugene.
Piggy's. How many prior felonies do you show that would count for habitual?
Oh, okay, 1 second. He's a little bit older. Let me open up another.
Yeah, he's currently serving a homicide case from 2010. You're breaking up, Mr. Moore. You're breaking up really bad.
Okay, I need to pull up another system real quick because he's older.
Can't say he's older because he's a lot younger than me. That makes me ancient.
No, well, the case, the case, you know.
Okay, clarify, Mr. Moore.
Okay. 1, 2. Looks like I'm gonna say it looks like 2.
Is there receiving and concealing?
Well,
That he would-
you know, stolen. Yeah, there's a receiving, concealing stolen property.
But he got a height on that, right? So it wouldn't count.
Well, you do count it. If it is, it doesn't show that he received a height on there. What I'm looking at, if he did get it, we still count it for guidelines. And then the murder
Not
second
as a
degree.
habitual, but it wouldn't count as a sup for habitual offender, right?
I always thought well, that's a prosecutor question. I always thought even though they had that, we count it.
All right, Ms. Underwood,
Come up to the microphone.
yeah, Ms. Spade's not picking you up.
I would probably counsel Mr. Piggy's because it's a tail anyway, to do the 1 count.
Yep, that's what I would probably say would be in his best
Do the 1
interest.
count.
Okay. Okay, so, all right, so.
This is gonna have to go way up.
Find a mid-ground for you too, so, all right. So, Mr. Piggy's, thank you for your patience this morning. So, Mr. Piggy's, can you raise your right hand for me, please? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? All right, so you gotta speak up for us. Okay, thank you. So, Mr. Piggy's, we've had a long discussion on the record about the plea offer and your options, okay? So if you were to plead to count 1, assault of a prison employee as charged with 1 sup, that will make your maximum penalty up to 7.5 years in prison. That would be your tail, right? And the other offer was plead straight up to count 1 and count 2, which are both 5-year felonies, so the tail would be 5 years, but that would add 2 prior felonies to your habitual offender notice, okay?
Yes.
And I believe there was an okay, so you've had a chance to talk to your attorney about that?
Yes.
So is it your intention then to plead to count 1 assault of a prison employee with 1 sup? That makes it a 7.5 year tail. Is that what you're recommending, Ms.?
Yes, and we are also requesting the low end of the guidelines.
Right, which is standard on these. So do you understand that?
Yes.
Okay, so my bailiff's giving you your advice of rights form. If you could just take a moment, read through it, and then ask Miss Underwood any questions. We'll have you date it and sign it, and then I'll go over them with you on the record.
Yes.
You understand?
Yes, ma'am.
Okay. Right, the record should reflect, I received that signed copy of the signed advice of rights. So now I'm gonna go through those rights with you. So, Mr. Pegues, it's your intention today then to plead to count one, assault of a prison employee with one sub, which carries a maximum penalty of 7.5 years in prison, is that correct?
Yes.
Now, you've had ample time to speak with your attorney. Are you satisfied with her as your attorney and the advice that she's given you?
Yes.
All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court, but Ms. Underwood did request that I sentence you to the low end of the guidelines, which is standard on these cases. Do you understand that?
Yes.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Pegues, do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that?
Yes, ma'am.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
All right. Do you understand if your plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So you're incarcerated, so obviously you will show up for sentencing. But if you get in trouble again and assault another prison correction officer, you understand I wouldn't be bound by any of our agreements.
Yes, sir.
Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, sir.
Okay, so Mr. Pegues, how do you wish to plead to the charge that on or about March 16 of 2025 in Madison Township in the county of Lenawee, that you did commit the offense of an assault of a prison employee?
Guilty.
Okay, and you have a prior conviction from August 11 of 2010 for second-degree murder in Wayne County, is that correct?
Yes, sir.
Okay, so you're also pleading to that one habitual offender, correct?
Yes, sir.
Okay. All right, has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, sir.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the agreement and the plea bargain that was placed on the record to induce the defendant to plead guilty? Ms. Underwood?
No.
And Mr. Sneed?
No, Your Honor. Thank you.
Could you repeat that, Ms. Underwood? Repeat your response.
No.
Okay. All right, and all right, has your attorney, other than the cops to the low end of the guidelines, promised you anything else about your sentence?
Okay.
And you understand we don't have a final number of what your guidelines will be today?
Yes, sir.
Okay.
Sir, please speak up. I'm
Oh,
sorry.
Yes, Judge.
Thank you.
Okay.
Sorry about that.
All right, is it your own choice to plead guilty?
Yes, Judge.
Okay, so Mr. Pegues, on March 16 of 2025, were you at the Gus Harrison facility?
Yes.
Okay, and you were lawfully imprisoned there as a sentence for the second-degree murder, is that correct?
Yes, Judge.
And if I were to tell you that was in Madison Township in the county of Lenawee, would you agree with that?
Yes, Judge.
All right, and at that time, did you come in contact with a Traylon Hess, who was a correction officer there?
Yes, Judge.
All right, and at some point you assaulted them.
Yes, Judge.
Can you tell me what you did?
I punched him and threw him over the rail.
Okay. Okay. All right. Was it like a second floor rail or?
Less than 5 stairs rail.
Okay, okay. All right. And you knew that it was a criminal offense to do that and you're not allowed to assault a prison employee, correct?
At the time I wasn't thinking, but now I do know.
Okay. Okay. Mr. Sneed, are you satisfied?
Yes, thank you.
Okay, and then again, back on August 11 of 2010, you were convicted for second-degree murder in Third Circuit Court for Wayne County, is that correct?
Yes, Judge.
Okay, you said your out date is 2040?
2042.
42, okay. Has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
You have.
And Mr. Sneed?
Yes, thank you.
Accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence. In this case, with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the agreement to the law under the guidelines. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Pegues, where are you currently at? He's in Macomb?
Macomb Correctional Facility.
Yep. All right, so he's in Macomb. So Ms. Underwood, I know that we had some audible issues with him last time. Do you want him present in person or via Zoom for
You
sentencing?
want to come in person to your sentencing?
I would like that.
Okay, you have the right to be present in person. So I'm gonna set this matter for sentencing on March 20. And Miss Adams, what does the morning look like? Can I set it later? Because they're driving quite a bit. Can I set it for like 9:30 or 10?
You have a 10 o'clock guardianship review. There's
9:30.
That would work.
All right, so I'm gonna set this for sentencing on March 20 at 9:30 in the morning, okay? And we'll have you brought in person, we'll do the writ. And then, Mr. Pegues, somebody will come talk to you about the offense. Be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We'll get a copy to Miss Underwood. Miss Underwood's really good about getting in and meeting with everybody in advance of sentencing, but sometimes due to volume, it's harder to get in and out of the prisons for Zoom. If she's not able to meet with you in advance, she will have ample time to talk to you that morning, all right? Okay, we'll see you back on that day. Drive safe. Thank you.
Thank you.
Thank you. All right. Ms. Underwood, thank you. So before we start our bench trial, I'm going to take a 2-minute recess and then we'll come back. I would ask that all witnesses be sequestered. There seems to be a bunch. All right.
Yes. Stays in. Yeah, you'll be done.
Hey, how you doing? You're up here high now? You're up here high now, 3rd floor.
You're right for you to charm. Whatever I do. 3 months ago. Alright, keep dropping the weight. You're right.
Mr. Dagger, did you have a witness list, exhibit list? Thank you very much. I appreciate it. This is my-
Of course, yeah.
court copy? Do you have a copy for me?
I gave a copy to Alex and I have a copy for the judge. I can make another copy.
Yeah, I'll leave it eventually. Okay, thank you.
Please rise, circuit court's now in session. And you may be seated.
All right, so this is the matter of the people of the state of Michigan versus Timothy Neves, file number 25-2222 FC. This is the date and time scheduled for a bench trial in this matter. I have Michael Dagger Margosian appearing on behalf of Mr. Neves, and I have Alexander Banetto appearing on behalf of the people. Mr. Banetto,